Now, after learning section 66 and section 67, the next discussion that we're going to have now under the share capital chapter is section 68. Section 68 is all about buyback of securities. This section is very, very important from the examination perspective. From here, you can get any type of a question. You can either get a straightforward theory question, just testing you on a specific step, or testing you on a specific process on a specific point, a straightforward theory question, or you may get a case study based question, or in rare scenarios, you may get some practical questions where you may require some calculations. This section, buyback of securities, talks about a concept, buyback, which I'm sure is not new for you. You would have already heard of buyback earlier. In fact, you would have also done accounting for buyback in your accounts subject, right? So it is not something totally new for you all. Now, when I talk about buyback, all right, remember your knowledge in accounts, your accounting knowledge, whatever accounting entries, whatever calculations you have learned under buyback will help you. Some of you would have already learned it. Some of you might not have finished that chapter until now. You will be learning it in your CA intermediate also, in your accounts, in your accounting paper. Even CA intermediate, even CS executive, all these courses in the intermediate level, in the inter level, in accounts paper, you do have accounting for buyback. So your accounting perspective, you will anyways be learning over there. Here in company law, we will look at buyback from the legal perspective. What does the law say? From Companies Act perspective, we are going to look at buyback. Now, when the company buys back securities, okay, the company's capital reduces. You agree with me? Companies buying back, companies taking away the securities back from you. Obviously, the company's capital will reduce, because after the company takes the shares from you, company is going to cancel the shares. So earlier, the company had 5 lakh shares outstanding. Out of that, let's say the company buys back 2 lakh shares. After the company buys back 2 lakh shares, those 2 lakh shares will be destroyed. Those 2 lakh shares will be cancelled. So from 5 lakh shares, the company's capital reduces to 3 lakh shares. Yes, there is a reduction of capital. But then section 66, reduction of share capital process, is not applicable here. If you want to avoid section 66 reduction of share capital, under section 68, you have a list of conditions, a big list of conditions. All those conditions have to be fulfilled. Did you understand? I'll repeat again. Section 68 allows companies to buy back securities, but it puts a lot of conditions. If you fulfill all those conditions, even though it is actually a reduction of share capital, you don't have to follow section 66 process. See, section 66 process is a little complicated because you need NCLT's approval. It takes a lot of time also. NCLT will wait for 3 months for central government, ROC, SEBI and creditors and all to send objections. So section 66 is time consuming. It is resource consuming. It is complicated. Okay, so that is why you can avoid section 66. When you buy back, there is reduction of share capital, but you can avoid section 66 if you fulfill all the conditions given under section 68. If you don't fulfill the conditions given under section 68, then sorry, you have no choice. You will have to follow the section 66 process. Okay, now all the conditions under section 68, we are going to learn one by one, slowly, in full depth, we are going to study. Listen to me very, very carefully. You needn't write anything. Just listen to me. This entire notebook where I'm writing down concepts, I'm anyways going to be sending you all. All right. So just listen to me. Buyback of securities. What is the first condition? First and foremost, from whom is the company going to buy back shares? The company has generally three choices. The company can buy back shares from its existing shareholders on a proportionate basis. This proportionate basis is also called as pro rata. Proportionate or pro rata, this is nothing but a ratio. For example, the company will say, if you already hold 5 shares, I am going to buy back 1 share. So the ratio 1:5 would mean we are going to buy back 1 share if you already own 5 shares. So if you own 10 shares, we are going to buy 2 shares from you. If you already own 20 shares, we are going to buy back 4 shares from you. So when I say that the company can buy back securities from its existing security holders on a proportionate basis, it means that the company will come up with a ratio. How many shares do you hold? From that, how many shares are we going to buy back? So on a proportionate basis, from all the shareholders, on the basis of this ratio, the company will buy back shares. This is the first method. In the second method, the company again goes to its existing shareholders, but this time no ratio and all. The company straight away goes to the open market. Open market means what? If the company happens to be a listed company, the company will straight away go to the stock market. There, whoever is willing to sell the shares of the company, how many ever shares they are willing to sell, company will buy from there. Company can buy back shares from the open market. No ratio, nothing. Whoever is willing to sell the shares, how many ever shares they are willing to sell, no ratio, nothing. How many ever they are willing to sell, the company will buy back. Or third option, the company can also go to its employee shareholders. Sometimes the company might have given shares to employees either through the ESOPs route, employee stock option plan, or through the sweat equity shares route. Both these concepts we have already learned in depth, not going through it again. From whom is the company going to buy back the securities? First point. The company can buy back securities either from the existing security holders on a proportionate basis, on a pro rata basis, on the basis of a ratio, where depending upon how many shares the shareholder already owns, proportionately from all the shareholders, the company will buy some shares. Second method, company goes to the existing shareholders and buys shares from them in the open market. When I say open market, no ratio. Whoever is willing to sell, how many ever they are willing to sell, company will buy back. Okay, and lastly, the company may buy back shares from its employee shareholders. The employees of the company who have also become shareholders of the company, either because of ESOPs or because of sweat equity shares, company can buy back shares from them. Okay, now listen, this was my first point, from whom is the company going to buy back. Now listen to my second point. See, when the company buys back shares from the shareholders, will the shareholders give these shares back to the company for free? Of course not, right? They will expect some consideration from the company. The company is going to the shareholders and the company is buying back the shares from the shareholders. So obviously, the company has to give some consideration to the shareholders. This consideration is called the buyback price. So the company needs money to pay off the shareholders. From where is the company going to take this money? What are the sources of funds that are allowed? What are the accounts that the company is allowed to touch? From where can the company take money and pay off the security holders for buyback? Company is given 3 options. Company is given 3 sources of funds. Section 68 says, company, you want to buy back securities? You need money to pay buyback consideration? We'll give you 3 places from where you can take money. Number 1, you can take money out of the free reserves of the company. Free reserves means what? The distributable profits. What are distributable profits, guys? Distributable profits are nothing but profits which are available for distribution as dividend. Generally, your accounts, your profits which are sitting under general reserve account, your P&L accumulated balance, they all become your free reserves. So number 1, you can take money out of your free reserves, out of your distributable reserves. Or number 2, you can take money out of securities premium. Do you remember, guys, earlier when I was teaching you about securities premium, I had told you that money in the securities premium account cannot be used for anything and everything by the company. There are strict restrictions. Company can use money in the securities premium account only for 5 purposes. Remember, we studied. And for Ind AS compliant companies, we studied out of those 5, only 3 purposes it can be used. Yes, and do you remember the last purpose we studied was buyback of shares? Yes, so when the company buys back shares, it is allowed to take money out of securities premium account. Yes, money in securities premium account is not available for use freely for anything and everything. It can be used only for certain specified purposes. And one of those specified purposes is buyback of shares. So when the company is buying back shares, yes, the company can take money out of securities premium account. Third option, the company can make a fresh issue of securities. The company can make a new issue of securities. When the company issues securities, for example, the company can issue new shares or the company can make a new issue of debentures. Whenever the company issues securities, obviously the company is going to receive money. That money, the proceeds, instead of money, we will use the word proceeds. Proceeds of fresh issue of securities also can be used by the company to buy back shares. So, second concept under buyback. What are the places from which my company can take money? Free reserves, securities premium, proceeds of fresh issue of securities. Come on, repeat again. Free reserves, securities premium, proceeds of fresh issue of securities. Keep repeating along with me, please. All right. Please try learning of all these concepts right now along with the lecture. No point sitting for the lecture for 1 hour and then again spending 1 hour at home learning all this. No. The whole objective behind having such detailed lectures is so that you can finish off the learning with me. All these concepts don't require extra time at home. So please pay attention. Please keep repeating. Let all these concepts get registered with me right now, right here. Now listen. I'll tell you a mistake which students make. Instead of writing the third point, fresh issue of securities, they just write proceeds of issue of securities. This word fresh over here does have a significance. What is the significance? Listen, in case the company had made an earlier issue, long back, the company had issued some securities. From that, the company had obtained money. Can that money be used by the company to make can that money be used by the company for buyback now? The answer is a big no. The company is allowed to take money only out of fresh issue of securities. This discussion should remind you to write the word fresh, because the company is not allowed to touch the proceeds of earlier issues of securities. The company can either take money for buyback out of free reserves, or the company can take money out of securities premium account, or the company can now make a fresh issue of securities, take money from there. Earlier issue of securities, money is still available? No, you cannot touch that. Earlier issue of securities, you cannot use that money. Okay, one more point. In case the company is taking money out of free reserves or out of securities premium account, then whatever is the face value of shares which the company is buying back by taking money out of free reserves or securities premium account, that has to be transferred into a separate account called CRR. What is the full form of CRR? I'm sure you guys know about it. Capital Redemption Reserve. And what are we going to do with the money in CRR? Money in CRR can be used only for one purpose, and that is what? To issue fully paid bonus shares. Now, think. Similar concept. In fact, I shouldn't use the word similar concept. I should use the word same concept. Same concept we studied a little earlier in the share capital chapter. Do you remember where? Transfer to CRR, CRR money to be used only for bonus shares. Are you able to link this provision with a concept which we have already studied? Where did we study? Do you remember? Remember redemption of preference shares? There also we studied the same thing. Even there we studied we can take money out of free reserves, or we can make a fresh issue of securities, take money out of there. But their securities premium account can be used only to pay premium on redemption, not the face value, only the premium portion, the premium on redemption, that alone you can pay out of securities premium account. I hope you are able to connect. We had studied in full depth earlier, right? So even over there, we had studied that if you take money out of free reserves and all, then whatever is the face value of the shares which you are redeeming by taking money out of free reserves and securities premium has to be transferred to CRR. Same point even over here. Not proceeds of fresh issue, not from point number 3, from point number 1 or from point number 2. If you're taking money to buy back shares, you will see how many shares are you buying back by taking money from place 1 and place 2. Face value of those shares you have to transfer into capital redemption reserve account. And whatever funds have been transferred to capital redemption reserve account, they shall be used only to issue fully paid bonus shares. This is it about point number 2, concept number 2. So under buyback, first we learned from whom is the company going to buy back shares? From whom is the company going to buy back securities? Number 1, existing shareholders on a proportionate basis. Number 2, existing shareholders from the open market. Number 3, from those employees who are also shareholders of the company. How did they become shareholders of the company? Company would have given them either sweat equity shares, or through ESOPs route, they would have become shareholders of the company. Second concept we learned, from where is the company going to take money for buyback? 3 places: free reserves, securities premium, and proceeds of dash issue. Don't forget, proceeds of fresh issue of securities. We cannot use leftover money of earlier issues of securities. We have to make a fresh issue. If we take money out of place 1 and place 2, we will see how many shares are we buying back out of such money. That much amount, face value of those shares, we have to transfer to capital redemption reserve. Please note, please identify, I am saying face value of those shares have to be transferred to CRR, not the consideration that we pay for the shares. Consideration that we pay for these shares will be way more than face value. Buyback price generally will be way more than face value. In fact, buyback price will also be more than the market price generally. I remember some time back, some 3 or 4 months back, this company, Ajanta Pharma Limited, it's a pharmaceutical company, Ajanta Pharma. This company had rolled out a buyback. Okay, I'm not sure about the exact numbers. As far as I remember, the company's market price was somewhere around 1,400, and they had announced a buyback where the buyback price would be 1,800. So the market price is 1,400, buyback price is 1,800. Buyback price will generally be even more than the market price. That is a motivation that shareholders will get. Otherwise, they will think we might as well sell the shares in the market if the market price is more than the buyback price, isn't it? So to give a motivation to the shareholders, buyback price will generally be even more than the market price. Okay, so anyways, coming back to my Companies Act. So sources of fund, 3 places we have learned. In case we take money from place 1 or from place 2, then whatever is the number of shares that we are buying back out of this money 1 and money 2, face value of those shares we have to transfer to CRR, face value of those shares and not the buyback price. Okay, now coming to the next point. The third point under buyback. Listen to me. We also have to make sure for buyback that the articles of association of the company should authorize the company to buy back. Now you know what my next question is going to be. What if the articles of association does not authorize? And I know you will be able to give me the correct answer. By now you are a pro at all this. If articles of association does not authorize, we'll have to alter the AOA. And how are we going to alter the AOA? You know very well, we are going to alter the AOA by passing a special resolution. And now you know what I'm going to ask you next. What is a special resolution? You know the answer. Special resolution means number of votes in favor should be at least 3 times number of votes against. Simple point. In so many places we have seen this. Now listen, the fourth point under buyback. We need some approvals. Okay, whose approvals do we need? Whose approval do we need depends on how much money are we going to spend on buyback. Okay, if the total funds which we are going to spend on buyback, is nothing but buyback price into how many shares are we going to buy back. Basically, total how much consideration is the company going to pay for the buyback. If the total amount which the company is going to spend for the buyback is within 10% of 3 things: paid up share capital plus free reserves plus securities premium account, then just a simple board resolution is required, nothing else. Okay, if the funds which we are spending for buyback, the buyback price into the number of shares which we are going to buy back, if the total amount which we are going to spend on buyback is within 10% of paid up share capital plus free reserves plus securities premium account, then a simple board resolution is enough. But if the company is going to spend more than 10% of paid up share capital plus free reserves plus securities premium, then just board resolution is not enough. We will also need an approval of shareholders. And how are we going to obtain this approval? We will obtain this approval in the form of a special resolution. Is this also clear? Yes. So how are we going to write this in the examination? You should say, if the total funds incurred for buyback or total funds utilized for buyback do not exceed 10% of paid up share capital plus free reserves plus securities premium account, then a board resolution will be sufficient. But if the company is going to spend more than 10% of paid up share capital plus free reserves plus securities premium for buyback, then a special resolution has to be obtained from shareholders. Clear with the approvals, guys? Remember the 10% number. Okay, so if the company is going to utilize up to 10% of paid up share capital plus free reserves plus special plus securities premium, just board resolution is enough. But if the company is going to utilize more than 10% of paid up share capital plus free reserves plus securities premium, then special resolution will be required. We have learned 4 concepts until now under buyback. First of all, I taught you from whom are we going to buy back. Then we learned sources of funds. From where are we going to take money to buy back? Then we learned articles of association authorization. And now we learned about approvals. Okay, now listen to my 5th concept under buyback. My 5th concept is about some limits that we have to follow. See, what is the maximum number of shares or what is the maximum number of securities which my company is allowed to buy back? There is a limit. My company has to follow this limit. There are totally 3 limits. This is the part which you would have either already studied or which you will be studying under accounts. You have totally 3 limits. Okay. On the basis of all these 3 limits, you will find what is the number of shares which the company can buy back. Out of these 3 numbers, you will pick whichever is least. Company can buy back only that many securities. All right, I'll repeat again in case you did not follow. There is a limit. At the maximum, how many shares can the company buy back? There is a limit. There are totally 3 limits. On the basis of each of these 3 limits, independently, you will find out how many securities can the company buy back. So 3 limits, so 3 numbers you will have. Out of the 3 numbers, you will pick whichever is the least. That will be the number of securities that the company can buy back at the maximum. What are the 3 limits? Limit number 1. At the maximum, the amount of money which the company can utilize can be 25% of paid up share capital plus free reserves plus securities premium. This is called the resource test. How much resource is the company investing, or how much resource or how much money is the company utilizing for buyback? At the maximum, company can use only 25% of paid up share capital plus free reserves plus securities premium. This is the first limit. The second limit is the shares outstanding test. At the maximum, how many shares can the company buy back? At the maximum, company can buy back only 25% of total equity shares. At the maximum, company can buy back only 25% of total equity shares in a year. Third limit. Third limit is a debt equity test. After the buyback, if you see the debt equity ratio means what? Debt by equity. This should be less than or equal to 2. Now here, what does equity mean? Here, equity would mean same three things, guys. Paid up share capital plus free reserves plus securities premium. 3 tests, 3 limits. Independently, you will calculate. You will get 3 numbers. Out of these 3 numbers, you will pick whichever is the least. That is the maximum number of shares that the company can buy back in the current year. First test, resource test. Second test, shares outstanding test. Third test, debt equity test. The first test tells us that at the maximum, the company can utilize only 25% of paid up share capital plus free reserves plus securities premium account. The second test tells us at the maximum, my company can buy back only 25% of the total equity shares outstanding in that year. The third test says after buyback, the company's debt equity ratio should not be more than 2. The debt equity ratio should be less than or equal to 2. In simple words, debt should be less than or equal to 2 times of equity. Equity means paid up share capital plus free reserves plus securities premium account. What did I say? Debt should be less than or equal to 2 times of paid up share capital plus free reserves plus securities premium. It should not be more than 2 after buyback. Okay. Now in the examination, you will not write these words: resource test, shares outstanding test, debt equity test. All that don't write in your law exam. All this is something which you will be learning in your accounting paper. Okay. But in your law paper, please do not write all these terms. Instead, you will have to write as proper sentences. The total funds being utilized for buyback should not exceed 25% of paid up share capital plus free reserves plus securities premium account. The total number of shares being bought back should not exceed 25% of shares outstanding in that year. After buyback, debt should be less than or equal to 2 times of paid up share capital plus free reserves plus securities premium. Do not worry how to write the limits in the examination. I'll give you a small note after I finish the entire discussion on buyback. Okay, so this is about the 3 limits. So under buyback, we first learned from whom can the company buy back shares. Then we learned from where can the company take money to pay the buyback price. Then we learned articles of association should authorize the company to buy back shares. Then we learned what are the approvals that the company requires. If the company is utilizing not more than 10% of paid up share capital plus free reserves plus securities premium, then board resolution itself is enough. But if the company is going to utilize more than 10%, then special resolution is required. And then we learned that there is a limit at the maximum. How many shares, how many securities can my company buy back? There is a limit. There are in fact 3 limits. So all the 3 limits independently calculate. See what is the number you get. Pick the least of those 3 numbers. That would be the shares, the number of shares that the company can buy back. Resource test, which talks about how much money can you utilize for buyback. The second test, which is a shares outstanding test, which tells us how many shares, the number of shares which you can buy back. Even here you have the 25% number. Even here you have the 25% number. And number 3, the debt equity test, which says after buyback, the debt, total debt in the company should not be more than 2 times the equity of the company. Equity as in paid up share capital plus free reserves plus securities premium. In debt over here, you will consider both secured and unsecured debt. This is about your limits. Okay, now listen to the next part of the discussion. Before we buy back shares, we must make sure there is a precondition. Before we buy back shares, we must make sure that those shares are fully paid up. Now let's connect this concept with provisions which we have already studied. Can you try to recall where exactly did we study this fully paid up condition already? Can you think? I'll give you a moment. I'll give you a moment to pause and think. Where exactly did we study that, a precondition that shares have to be fully paid up? You have to check that shares are fully paid up. Do you remember? In fact, I remember we have discussed this in two places already. In two places, in two provisions, we saw that the shares have to be fully paid up. No, I'm not talking about section 67. I'm talking about two places where we saw that, before you do that particular thing, you are supposed to make sure that the shares are fully paid up. I'm not talking about section 67. Sometime even before that we learned. Even before section 67 we learned it in two places. I'll tell you. Number one, when we learned about redemption of preference shares, even there we learned that before we redeem preference shares, we should make sure that the shares are fully paid up. Number two, when I taught you about bonus shares, bonus issue, even there we learned that before making bonus issue, we must make sure that the existing shares are fully paid up. In fact, even when I taught you about converting shares into stock, even there we learned shares must be fully paid up, only then you can convert them into stock. But right now I was actually thinking about these 2 points, whether you remember or not. So the precondition is that before we buy back shares, we must ensure that those shares are fully paid up. Always connect provisions like this. It will help you revise. See, automatically now what did we do? Now, subconsciously, we have also revised a little bit of redemption of preference shares, a little bit of bonus issue. This is how preparation should happen, especially in a paper like law. Okay, so what are the preconditions? The shares should be fully paid up. Only then you can buy back shares. Similar provision we also learned under redemption of preference shares and even under bonus issue. In case my company happens to be a listed company, then you have a lot of SEBI regulations also applicable for buyback of shares. All those SEBI regulations also we must make sure are being followed. What are those SEBI regulations? Not required right now. We are focusing on Companies Act. Okay, now listen to my next point. My next point is very important. You may get a standalone question just focusing on the next point possible. See, we have to inform the shareholders fully, properly about all the details connected to buyback. We have to give them a full disclosure of all points related to buyback. In case a special resolution is required, then a special resolution required, we just studied. Special resolution is required in case the company is going to spend more than 10% of paid up share capital plus free reserves plus securities premium. So in case a special resolution is required, obviously we have to call a meeting of shareholders. Only in the meeting they will pass the resolution. Now, how do we call a meeting of shareholders? To call a meeting, obviously we have to give them a notice saying where will the meeting be held, when will the meeting be held, what is the agenda of the meeting, all that. Now, to that notice, an explanatory statement has to be attached. To that notice, what are we going to attach? What is it called? An explanatory statement. In this explanatory statement, all details relating to buyback have to be written. The law talks about a lot of details which we are supposed to write in this explanatory statement. But I want you to remember just 5 things which you should write in this explanatory statement. The hint to help you remember those 5 things is stand. You understood my background? When the company sends a notice to the shareholders asking them to come for the meeting, to that notice, the company has to attach an explanatory statement. In this explanatory statement, the company will try to inform the shareholders everything about buyback. Through this explanatory statement, the company is going to give all disclosures relating to buyback. Only on the basis of this information, the shareholders will be able to make a decision whether they should vote in favor of buyback or whether they should vote against the buyback. So we should give them a proper disclosure of all material information. 5 things which should be written in this explanatory statement. Number 1, what are the shares? What are the securities that we are going to buy back? Which class of shares, which class of securities are we thinking of buying back? Number 1. Number 2, T. T stands for time limit. What is the time limit within which we plan to do the buyback? What is the timeline? When are we going to buy back? When are we going to complete the buyback? The entire timeline, the time limits within which buyback will be completed. Even that has to be mentioned in the explanatory statement. Number 3, A. A talks about amount. What is the amount that the company is going to utilize for buyback? What is the amount that the company is going to invest for buyback? N. Necessity, need. Why? What is the reason? Why is the company buying back shares? And D is the residuary. Any other disclosure which is going to be material for the shareholders in making a decision whether they should vote in favor or whether they should vote against. Understood? So these are the 5 important points which should be written in your explanatory statement. What is a hint? How are we going to remember these 5 points? Stand. Learn it with the hint. It will be easier for your brain to remember. S for which shares, which securities are we going to buy back? T for time limit. What is the time within which we are going to complete the buyback? A, what is the amount that we are going to spend for the buyback? What is the amount which we are going to utilize for buyback? N, necessity. Why? What is the reason, justification for buyback? And D, other disclosures of matters which are connected to buyback, which will be relevant for the shareholders to know. Understood until here? 100% clarity. Okay, so we began with the persons from whom the company can buy back. Then we learned from where is the company going to take money for buyback. Articles of association, authorization, approvals, the 3 limits, the precondition, and explanatory statement. These are the concepts which we have learned until now relating to buyback. Now listen to me. After this, we are going to be learning a set of time limits. Now, if you look at your study material, these time limits are spread across the entire discussion on buyback. One time limit is written here, one time limit is written there. There are a lot of time limits and they're all written in separate places, which makes it difficult for us to remember. It is these time limits which make this concept of buyback a little difficult for us to study. It makes us feel like, oh God, there is so much to study under buyback. But no, I will try to simplify it for you by bringing all the time limits together in one place. So in one place itself, you will have all the time limits. It will be easy for you. Totally, I'm going to talk to you about 5 time limits. Time limit number 1. What is the time limit for completing the buyback? See, listen. Once the company passes the resolution, in some cases, just board resolution is required. In some cases, special resolution is required. Whatever it may be, whichever resolution it may be required. Once the company passes the resolution, within 12 months from that date, the company should complete the entire buyback process. First time limit is to complete buyback. Buyback should be completed within dash months, within 12 months from the date of passing the resolution. Time limit number 2. Once the buyback is completed, from the date of completion of buyback, within 7 days, the company should extinguish the shares. The second time limit is for extinguishing the shares. The shares which have been bought back have to be extinguished within 7 days from the date of completing the buyback. Now, what does extinguishing mean? Extinguishing means destroying. The shares should be cancelled. The shares should come to an end. The share certificate should be burnt and destroyed. That is extinguishment. The shares which we have bought back should be extinguished, should be destroyed, should be removed. The share certificate should be burnt away within 7 days from the completion of buyback. Second time limit. Third time limit. Between two buybacks, how much gap is required? Between buyback 1 and buyback 2. Let's say today only the company has done a buyback. Now, when can the company buy back securities again? The company will have to wait for 1 year. After the company completes a buyback, the company can do another buyback only 1 year after closing the earlier buyback. In simple words, time gap between two buybacks should be minimum 1 year. Okay, first time limit, the company should complete the buyback within 12 months from the date on which resolution is passed. Second time limit, once the company completes the buyback, within 7 days, the company should extinguish the shares. Third time limit, between two buybacks, we need a minimum time gap of 1 year. Okay, this was my third time limit. Now talking about the fourth time limit. The fourth time limit is all about the buyback return. Very simple. From the date on which the company completes the buyback, from that date, within 30 days, the company should file the buyback return. With whom? With the ROC. In case the company happens to be a listed company, it should also be filed with the SEBI. Okay, so buyback return has to be filed within 30 days of completing the buyback. This is my fourth point, my fourth time limit. And my last time limit, in an interesting time limit, it talks about a cooling period. Listen to me. Once the company buys back shares, after that, it has to wait for 6 months. Only after 6 months, it can make a further issue of securities. Let's say the company made a buyback. Once the company completes the buyback, after that, if the company later wants to issue securities, for example, let's say the company wants to issue more shares, or the company wants to make a private placement, or the company wants to make a public issue, the company wants to make an IPO, any sort of an issue if the company makes, any securities if the company wants to issue, the company will have to wait for 6 months. This is your cooling period. The company can make a further issue of securities only 6 months after completing the buyback. But here, some exceptions are given. Within 6 months, during this 6 months period itself, if the company wants, it can make a bonus issue, no problem. Within the 6 months, if the company wants, it can issue ESOPs to employees. It can also issue sweat equity shares to employees during these 6 months. During these 6 months, it can convert debentures into equity shares, preference into equity shares. These conversions and all are allowed. But during these 6 months, the company cannot make any other issue of securities. Even rights issue, the company cannot make in the 6 months period. Company can make a rights issue also only after 6 months. Are all my 5 time limits clear for everybody? Yes. What is my 5th time limit? Let me repeat the 5th time limit alone again. Some of you might not have understood. The 5th time limit talks about a cooling period. Once the company completes a buyback, after that, later, if the company wants to make a further issue of securities, company will have to wait for 6 months. In this 6 months period, right after completing buyback, the company cannot make any subsequent issue of securities. There's a cooling period of 6 months. But in this 6 months, the company can make a bonus issue. The company can issue ESOPs to employees. The company can issue sweat equity shares to employees. Company can also convert debentures to equity, preference to equity. All this is allowed. But any other issue, rights issue, all that you'll have to wait for 6 months. These are your 5 time limits. Shall we run through the time limits once again? First time limit, once the resolution is passed, within 12 months, the company shall complete the buyback. Once the buyback is completed, within 7 days, the shares should be extinguished. Once the buyback is completed, for the second buyback, company will have to wait for 1 year. Once the buyback is completed, within 30 days, company shall file a buyback return with 2 people, with the ROC and with the SEBI. SEBI will obviously get involved only if it is a listed company. And once the buyback is completed, we have a cooling period of 6 months. Within the 6 months period, the company cannot make a subsequent issue of securities. That is it. I know you have notes in your hand in which all these time limits are written. But still, I am going to give you exactly 2 minutes time right now to quickly write down these time limits in your notebook. There is a reason why. There are 2 reasons actually. Number 1, when we write down something, we remember it for a longer time. And the bigger reason, the second reason, in your notes, these time limits are written as theory points. But right now, I want you to write down these 5 limits in your notebook in exactly the same way in which I have depicted on your screens over here. This method of writing will make it easier for you to revise the day before your exam. The day before your exam, when you're flipping through your pages, you look at this, in a minute, revision will get completed. So come on, exactly the same manner, please write down in your notebooks. I'll wait for you all. I'll give you exactly 2 minutes. Come on, quick. I hope we are all done writing by now. Now, after this, we just have a few more points left. Listen to me. Every company that buys back securities will have to maintain a register of buyback. In this register, all details relating to buyback, for example, how many shares has the company bought back, for what buyback price, when did the company cancel the shares, when did the company complete the buyback, all details relating to buyback should be written in this register. So the company which is buying back shares will have to maintain a buyback register. This is simple. Now, the next point that I'm going to discuss with you all is another very important part of our buyback discussion. Again, you can get an independent question asking you just about this point. A plain theory question is possible on this. Very important. There are some keywords over here which I would like you to remember. Listen to me. Declaration of solvency. Before I start discussing the concept with you, before I start discussing with you what exactly the law says about this, let me give you some background. Let me help you, build a picture in your mind. See, listen, the company is buying back shares, which means what is the company doing? The company is giving money to the shareholders. The company is returning money to the shareholders and canceling their shares. The company is giving money to the shareholders. Don't you think the creditors will get angry? Why? Don't you think the creditors of the company will get angry? See, they will. If the company is buying back shares, company is using its money to give to shareholders. But if the company has money with it, isn't the company supposed to use this money first to repay the outsiders, to repay the creditors? Same logic which we learned even in reduction of share capital. Yes, if the company has money, the company is supposed to use this money and repay the creditors. Instead of repaying the creditors, company is letting the creditors, the loans and all, the company is letting the loans stay outstanding, and instead company is taking money and paying off to the shareholders. The creditors are again going to create a ruckus over here. They are going to get angry. So we are supposed to now convince the creditors that creditors, don't worry. Yes, before paying you, we are paying the shareholders. Yes, we are doing that. But don't worry, we have enough money for you also. That is the whole logic behind this declaration of solvency. Do you understand? Yes, through the declaration of solvency, we are telling the creditors, yes, we agree. Without paying you, we are paying off our shareholders. But you have no reason to worry. We have enough money for you also. This will convince my creditors at least to some extent. Now, this declaration of solvency has to be signed by at least 2 directors. It has to be signed by minimum 2 directors, and one of these directors should be the managing director of the company. There is a format. It should be in the prescribed format. It should follow the prescribed form. Before buying back, the company will have to file this declaration of solvency with the ROC and the SEBI. SEBI obviously only if it is a listed company. Before buyback, first file this declaration, only then you can do the buyback. This declaration should also be verified by an affidavit. What is affidavit? Something like a written oath. It's like a written oath, like a written declaration. When I say verified by an affidavit, it means you are giving out a view that whatever is written in this declaration is true. When I say it is verified by an affidavit, it indicates that this declaration is a reliable declaration. It is an honest declaration. It should be verified by an affidavit. All this is fine, but what are we going to write in this declaration? What is the content of this declaration? 2 points. First of all, the board of directors will write that the board of directors have made a full inquiry into the affairs of the company. They have properly inquired into the company's affairs, and on the basis of that inquiry, they have formed an opinion. They have formed 2 opinions on the basis of that inquiry. Opinion number 1, that the company is capable of meeting its liabilities, which means company has enough money to pay off creditors also. And opinion number 2, according to the board of directors, next 1 year at least, company will not go insolvent. Next 1 year at least, company is not going to be bankrupt. That is all. This is declaration of solvency. before the company buys back securities, the company is supposed to file a declaration of solvency with the ROC, and if it happens to be a listed company, it shall also file it with the SEBI. This declaration has to be in the prescribed format. It has to be signed by minimum 2 directors, and at least one of the directors signing should be the managing director of the company. This declaration should also be verified by an affidavit. This affidavit will give a picture that this declaration is an honest declaration. In this declaration, the board of directors will write that they have made a full inquiry, keyword. Board of directors have made a full inquiry into the affairs of the company, and they are of the opinion, keyword, opinion. They are just giving their opinion. They are not certifying. They are just giving an opinion that according to them, the company will be capable of meeting its liabilities and it will not be insolvent for the next 1 year at least. These things which I have just boxed in red, important. Board of directors have made a full inquiry into the affairs of the company, and they are of the opinion that the company is capable of meeting its liabilities and will not go insolvent for the next 1 year at least. Clear about this? This is about our understanding on declaration of solvency. After this, we just have one last concept under buyback. But before we do that, I'm going to show you the theory on declaration of solvency. We are all going to read that together. Okay, slowly, carefully, you will read this together along with me. Declaration of solvency to be filed with ROC and SEBI. SEBI only if it is a listed company. When? Before making the buyback. How? In the prescribed format, verified by an affidavit. Signed by at least minimum 2 directors, one of whom shall be an MD. To the effect that the board of directors has made a full inquiry into the affairs of the company. Accordingly, it has formed an opinion that the company is capable of meeting its liabilities and will not go insolvent within a period of 1 year of the date of declaration. All clear? Did we understand this discussion? Yes, I'll pause for a moment over here. Just give this declaration part one last reading and then we will proceed. Going ahead to the last part of buyback, a company will not be allowed to buy back in some cases. There are some restrictions. For example, a company will not be allowed to buy back securities if it has defaulted, if it has committed a default in repayment of deposits. Remember, even we spoke about this even earlier. Repayment of deposits, another R we will talk about redemption of what? Another D, redemption of debentures. When we talk about redemption of debentures, we will also talk redemption of preference shares. So if the company has committed a default in repayment of deposits or redemption of debentures or redemption of preference shares or paying interest on deposits or paying any interest on debentures or paying any dividend on preference shares, or if the company has defaulted in the repayment of any loan to a bank. Okay, if the company borrowed a loan from a bank and if the company is not repaying that loan or interest on that loan, then the company should first rectify the default. After rectifying the default, for the next 3 years, company cannot buy back securities. Okay, then a company cannot buy back securities through its subsidiary company. It cannot give financial assistance to its subsidiary company and say, use this money to buy my shares. It cannot buy back shares through a subsidiary company. Same way, it cannot buy back shares through an investment company. Also, it should not have any subsisting default relating to filing annual return with the ROC, filing the financial statements with the ROC, or relating to dividend declaration. That's all. So if the company has committed a default, all right, relating to repayment of deposits, redemption of debentures, redemption of preference shares, paying the interest or dividend to them, or repayment of a loan borrowed from a bank, then rectify the default, and for the next 3 years, you cannot buy back shares. Only after that, you can buy back shares. Company cannot buy back shares through a subsidiary company, through an investment company, and also if it commits a default relating to filing annual return with the ROC or filing financial statements with the ROC, or if it has any subsisting default relating to dividend, it will not be allowed to buy back securities. That is it with our discussion on buyback. All right, giving you a quick run through. From whom can the company buy back shares? Come on, keep repeating along with me. Keep giving me quick answers. Let's close this with 100% confidence. We can buy back securities from existing shareholders on a pro rata basis, or from existing shareholders from the open market without any ratio and all, or from our employee shareholders to whom we had given shares in the form of ESOPs or sweat equity. Then to buy back shares, we have to give consideration to those shareholders. We can take money out of free reserves, out of securities premium, or out of proceeds of fresh issue of securities, not leftover money of earlier issue. In case we are taking money out of free reserves, or in case we are taking money out of securities premium, then with that money, how many shares are we buying back? Face value of those shares we have to transfer to CRR, which shall be used only to issue fully paid bonus shares. Articles of association should authorize if we are spending not more than 10% of paid up share capital plus free reserves plus securities premium, board resolution itself is enough. But if we are going to utilize more than 10%, then we need special resolution. Total amount being utilized for buyback should not exceed 25% of paid up share capital plus free reserves plus securities premium. Total number of shares which I'm going to buy back should not be more than 25% of total equity shares. Debt equity ratio after buyback should be not more than 2. My shares should be fully paid up, only then we can buy back. In case I'm a listed company, even SEBI regulations should be followed. Remember my hint stand? Yes, in the explanatory statement, we'll have to write which class of shares or securities are we buying back, what is the time limit within which we are going to complete the buyback, what is the amount which we are going to spend for buyback, what is the necessity, what is the need, what is the justification, why are we buying back, and disclosure of any other material fact. We must complete the buyback within 12 months of passing the resolution. Then we must extinguish the shares within 7 days of completing buyback. After completing the buyback for the next 1 year, you cannot make a buyback again. After completing the buyback, within 30 days, file a buyback return with ROC and SEBI. SEBI only if it's listed company. Cooling period 6 months, within which you cannot make a further issue of securities. You'll also have to maintain a register of buyback. Company will also have to file a declaration of solvency with ROC and SEBI before making the buyback. In this declaration, the board of directors will mention that they have made a full inquiry into the affairs of the company, and they have formed an opinion that the company will be capable of meeting its liabilities and that the company is not going to go insolvent at least in the next 1 year. And lastly, we learned that in case my company has defaulted in repayment of deposits, redemption of preference shares, redemption of debentures, paying interest or dividend on them, repayment of loans to bankers, then the company should rectify the default, and for the next 3 years, the company cannot buy back shares. Also, company cannot buy back shares through a subsidiary company, through an investment company. And also, if the company has a subsisting default relating to filing the annual return or the financial statements with the ROC, company cannot buy back securities. This is it with buyback. I hope all of you are crystal clear with the entire discussion. Yes, I do have a lot of examination questions and a lot of mock test questions to discuss with you all relating to buyback. But do not worry, I will not take up right now. It will become too much for you all to remember, too much for your brain right now. With this, I will close this lecture here. In the next lecture, I will start with giving you all the notes for the limits. Remember, I was telling you all that for the limits, I will tell you all these limits. For the limits, I told you all, I'll tell you all how to write this in the examination. So the notes for this, I'll start with this in the next lecture. And after that, in the next lecture, we'll discuss all those questions. Okay, I'm not taking up right now. Okay.